Hi everybody. I want to talk to you today about how doing some of your own patent diligence and some of your own patent pre-prep can be like checking the oil on your car. You don't always need to rely on a mechanic, and you don't always need to rely on an attorney. There's things you can be doing for yourself that can save you time, money, and make your patent process a lot easier, a lot smoother, and cost a lot less money. My law firm and myself, we look at ourselves as patent mechanics. I look at myself as a type of patent mechanic. I see a lot of interconnectability between the two, and I'm going to show you a little about some things you can do and some steps to take money, and I'm also going to check my oil.
Okay, folks, I hope that makes sense about the analogy of a person who has a mechanic that works on their vehicles, but also checks their own oil and does certain things and isn't entirely reliant on their mechanic to do everything. I look at myself as a type of patent mechanic, that I help my inventors get filings, protect their intellectual property to the extent they can afford it, and to try to make themselves more appealing to customers and to outside investors. That doesn't always involve spending money. That doesn't always involve doing legal services that are unnecessary. Sometimes it involves getting the clients to do self-help and do things for themselves. Now, what will usually happen with my clients is they'll do a provisional themselves, and then they'll come to me and we'll eventually convert that provisional into a utility app. Let's assume that's the case, because that is the case with a lot of my law firm's client portfolio. Okay, so if that's the case, we're sitting here with a base utility application. As we all know, however, inventions, services, products pivot, change with the market, move as customers give feedback and as they make decisions about what kind of products they want to buy in the future. Things to do with pricing, things to do with reducing raw material costs and manufacturing considerations. In that case, what I might advise my client to do is to don't bring your car to me every time. Every once in a while, check your own oil. Every once in a while, file your own provisional. Even though we already have a base utility between us. That is the responsibility of my law firm. As you think up stuff, go ahead and grab a provisional if you want. Do it yourself. The filing fee might only be $70, might be $140. It's not going to be very much. We're not even sure if this feature or the value of it is going to necessarily be commercializable or marketable or really in any way enhance the invention or the company. We don't know that yet. But let's not try to get in a position where we have to predict that. Instead, file because it's so cheap. Check your own oil because it's so easy. You walk by your car all the time. Do something with it other than sit in the driver's seat. Take a look at what's going on under the hood. File your own provisionals. That's what's going on under the patent system's hood. Now, what we would do in that case, should it be a feature that's beneficial and that we need to protect, we'll file a later continuation in part that includes the base material along with the newer material from the provisional. Again, getting back to inventor self-help. Inventors checking their own oil every once in a while. In a lot of cases, because of the delay and how long it takes for a utility to even get examined, they may never even need the CIP. They may not even be in business a year from now. That invention might be kaput, dead, no longer usable, no longer marketable. We don't know. But this way you can protect yourself as you go along at relatively low cost. And if it turns out the invention kind of conks out, the service, the product, the manufacturing technique, whatever the invention is, just kind of fuzzes out, well, you minimize the amount that you wasted on the patent system by doing some of your own checking, doing some of your own filing, checking your own oil. Again, this assumes and is predicated on the assumption that my client base can do their own provisional filings, and some of them are unwilling to do so. And that my client base, the empowered and enlightened ones, are willing to kind of test out their ideas and decide whether they need a CIP. They may not. Or if it's not clear whether this is going to be part of the final embodiment of the invention, do a low-cost provisional, incorporate it in later. These could potentially have legal ramifications, and this is not legal advice. You may wish you had that earlier priority date, but that's not always good economics. And it involves running up legal expenses, running up a bill with your patent attorney, and doing filings that may in the end turn out to be a bad use of your money. So this is a risky strategy. This is not a guarantee that you definitely want to do this. It's an option available to my inventors that are somewhat constrained on cash. That's why I offer it to them. Let's move to another chart. The utility patent process takes a long time. There's just no getting around it. I set up this timeline, and I know this is a busy, complex chart. I realize that. But I set up this timeline based on the fact that I filed a utility filing, and over here, before time even is shown, that the inventor had essentially some kind of provisional. Now here, at time base 0, we move to the utility filing. The first office action is probably not going to come for 18 months. Inventions change a lot in 18 months. Companies change, people change. You hire new service providers, you fire old ones. All kinds of things change. We got a non-final, and then, going to be 7 months before the examiner gets back to us again. We're already looking at almost 2 years. In that time, inventions are going to change a lot. If that's the case, step on over here and document and occasionally file and protect your improvements and alterations along the way. Because remember, at this time here, no new information, no new matter can be added to this utility application. It has to be added in a new separate application with a new separate priority date. So this is a strategy I work out for my inventors, knowing that inventions pivot, knowing that the patent system takes a long time, and knowing that some of my inventors are empowered enough that they can do their own provisionals in the same way that an auto mechanic hopes that his people who bring his car into him hopes that they check their own oil occasionally. Check for an oil leak. See if you got problems. You're dependent on your vehicle. Almost anybody watching this video is dependent on their vehicle working and functioning properly. In the United States, it's almost impossible to get by without a car. And if you let your engine run out of oil, you got problems. People learn, but they don't do it for whatever reason. They don't check their own oil, but you should know how. Moving back to this chart, one of the other bad news of this is how long it takes to get a patent, or even to be talking about it. From the filing of the utility, 25 months here, another 2, 27, 30 months. That's 2.5 years before we even get to start talking about allowance and potential issuance of a patent. So that's 2.5 years of sitting in the office. Your invention could have changed so hugely from 2.5 years ago that this information filed here is no longer even relevant. This is a busy chart. I'm going to use it a lot in a lot of my videos. This was just to give you an idea of the timeline, give you an idea of advantages and value to being your own best supportive person as far as doing at least some of your legal work. And yes, it quite literally is comparable to checking your own oil.
Folks, I gotta be honest with you. I wanted this video to be shorter. I wanted it to use less of my words, less talking, less graphics, and get the point across. But doggone it, the patent system is complex. It's not easy to briefly and quickly explain. And the concepts I laid out in here aren't easy either. Unfortunately, the way to save money on the patent system does involve quite a bit of inventor level understanding. Don't rely on just your attorneys to tell you everything. Try to see behind why the rules are what they are and how to make the best of it. It's not easy. I wonder how many people are going to actually watch this video all the way through, because it is not an easy lesson that I'm trying to convey here. But it is a good lesson, and one that can save inventors money.